Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Daniel McKeer is back in court, and this time he's about to learn the hard way why having proper legal representation is absolutely essential. If you're just tuning in, this is part 2 of his ongoing saga, and from the moment he steps into Judge Simpson's courtroom, it's clear he hasn't learned much. He's unprepared, unrepresented, and carry himself in arrogance that immediately sets the wrong tone, refusing to answer the judge's questions, chewing gum while seated before the bench, and acting as though he's above the process. It's a perfect example of what not to do in a courtroom, without an attorney to guide him. McKeer stumbles through proceedings, displaying the kind of misplaced confidence that often turns small problems into big ones. Court isn't a place for attitude. It's a place for respect, preparation, and understanding the gravity of the situation. As this hearing unfolds, we'll see exactly why ignoring those basics can turn a bad start into a total disaster.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals. Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that to sort of reconcile both of those things as whether or not discovery is something the defendant is prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
Deal with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
This hearing is a clear warning of what happens when confidence overrides common sense. Daniel McGeer seems convinced that he can outsmart a sitting judge, a mistake that never ends well. His attitude mirrors that of self-proclaimed sovereign citizens, people who act as if the law doesn't apply to them, and the result is predictably chaotic. He's facing serious charges for assaulting a police officer, and even lost custody of his child because of that incident. Yet he treats the matter like it's no big deal. Instead of showing remorse or respect, he argues, dismisses questions, and keeps digging himself deeper. Watching him handle his case alone is like watching a slow-motion train wreck. You can see the outcome long before it hits. The truth is, representing yourself in court rarely ends in your favor. It's not about pride. It's about protection. By ignoring that, McGeer only makes the situation worse, alienating the judge, frustrating the court, and proving exactly why the phrase, "a man who represents himself has a fool for a client," still holds true today.